Good afternoon and welcome to those of you that have joined. We have just opened the link, so we're just waiting for a few minutes to allow everybody to join before we start. Good afternoon and welcome to those of you that have joined. We've just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Good afternoon, everybody, and welcome to the Five Stone Buildings webinar program. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Whilst we are waiting for everybody to join, I shall just remind you of the house rules. So just to let you know that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box and our speakers will try to come to the questions at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box and our speakers will not identify you when responding to your question. And just to remind you that we now have a webinar page on the Five Stone Buildings website where you will be able to see a copy of this recording and the slides used and any previous webinars. I will now hand over to Raj.
Thank you very much, Jo. And well, welcome. Good afternoon. Welcome to the Five Stone Buildings webinar. Thank you very much for joining us. My name is Raj Arumugam. I'm a barrister at Five Stone Buildings. Today we'll be talking about cross-border insolvency in the EU post-Brexit, and we're particularly looking at issues of recognition and enforcement. I'm delighted to be joined in today's webinar by Alice Lithgow and Adam Cole. Alice is a partner at Fletcher Day here in London in their litigation group. She has extensive experience and a broad practice, which includes company and commercial litigation, insolvency, and charity matters. Adam is a partner in Walker's insolvency and dispute resolution team over in Guernsey. He has wide commercial litigation experience and a particular interest and experience in contentious insolvency matters, regulatory enforcement, and trusts disputes. It's my pleasure to have them join me today and to have the benefit of their experience and views in this area. So I start off with an obvious proposition. Joe, can we have the next slide, please? When we have insolvencies with a cross-border element, cross-border cooperation is obviously essential, and it's vital that office holders and court orders in one jurisdiction are recognised in the case of orders capable of enforcement in another jurisdiction with the minimum of fuss. Now, as we know, the UK formally left the European Union on the 31st of January 2020. There was an 11-month transition period or implementation period, which ended at 11 p.m. on the 31st of December 2020. The trade agreement that was reached rather at the 11th hour on the 30th of December did not include any provisions in relation to insolvency. And so what we have effectively is a hard Brexit in insolvency law, and I know that phrase has been used more than once in the context of insolvency. Now, there were, as I put up on this slide, you can see that there are three main pieces of legislation to think about, really four, which we had up until the 31st of December 2020. So we had the Lugano Convention, which governs jurisdiction and enforcement of judgments between the EU and EFTA countries, so that's Switzerland, Iceland, and Norway. The Lugano Convention was a mirror image of the 2001 Brussels regulation, which is Regulation 44/2001. And that's the EU regime governing jurisdiction and enforcement of judgments for proceedings starting before the 10th of January 2015. Of course, that was replaced by the Brussels recast regulation, or the judgments regulation, which is Regulation 1215/2012. And that applies to proceedings from on or after, which were commenced on or after the 10th of January 2015. Now, the purpose of those regimes governing jurisdiction and enforcement of judgments between the UK and the EU was to promote cross-border judicial harmony and cooperation. So we would have straightforward enforcement of judgments, and it provides legal certainty, predictability for the parties, so they could identify the courts in which they needed to go to sue a party and where they might be sued themselves. Now, none of that applies to bankruptcy and winding up of insolvent companies. Insolvency falls within the insolvency regulation. Now, all of this has been, to a large extent, swept aside with the end of the transition period at 11 o'clock on the 31st of December 2020. Next slide, please, Joe. So there are really, from an insolvency perspective, there are really three key changes which impact cross-border insolvency since then. So the first is the EU, or concerns the EU Insolvency Regulation 2015/848. Now, that no longer applies in the UK to insolvencies opened after the 31st of December 2020. It's worth remembering that for insolvencies opened before that date, whether they're main proceedings or secondary proceedings, the regulation still applies. And there are 5 key points or key aspects in insolvency proceedings involving more than one member state, which we get from the insolvency regulation. First, in relation to jurisdiction, we had the introduction or the existence of COMI as founding jurisdiction to open main insolvency proceedings in relation to the debtor. And COMI, of course, is the place where the debtor conducts the administration of its interest on a regular basis and ascertainable by third parties. We then had the position with secondary proceedings, which could be opened up in a member state where the debtor had an establishment, but those secondary proceedings would have been limited largely to assets within that member state. And then in the court where the main proceedings were going ahead, that court had jurisdiction in relation to actions deriving directly from or closely linked with the insolvency proceedings. The regulation also dealt with applicable law. The courts in each member state applied their own laws to insolvency proceedings opened in that member state, with some exceptions, for example, for immovable property. But what this meant was there was a relatively uniform conflict of law, set of conflict of law rules for insolvency proceedings for most or for many purposes. And then finally, the regulation also dealt with, crucially, recognition and enforcement. So insolvency proceedings in one member state were automatically recognized in all other member states and would have the effect in each member state that they would have in the state in which the proceedings were opened. Now, with effect from 11 o'clock on the 31st of December, Regulation 2015/848 was actually amended in English law by the Insolvency Amendment EU Exit Regulations 2019. And the effect was to very, very significantly slim down the insolvency regulation, so that none of those 5 rules now apply in England and Wales, or indeed in the UK. Now, the only positive change, I suppose, that's been brought about by the 2019 regulations into English law is that English courts now have jurisdiction to open insolvency proceedings where the debtor, or it's set out on a statutory basis, where the debtor has its commie in England. So that is clarified and set out in the by virtue of the 2019 regulations. But otherwise, the insolvency regulation is largely swept away. Now, this has implications for inbound and outbound proceedings. For outbound proceedings, so that is where there's a judgment in England, or there's an insolvency practitioner, a liquidator, an office holder in England who's looking for recognition in another country within the EU, so outbound in that sense. First of all, of course, insolvency proceedings are now no longer automatically recognised in EU member states. So this will significantly hinder an English office holder's ability to deal with assets in the EU. He or she is going to need to now commence additional recognition or local insolvency proceedings. And that's going to have an effect in terms of cost and delay, potentially. This also might lead creditors to start proceedings in the EU rather than in England, or to start main proceedings in the EU in parallel with English ones, if they can persuade a member state court that the debtor's commie is actually over there. So this has the potential to lead to a multiplicity of insolvency proceedings, perhaps in the most complicated of cases. And of course, it could lead to inconsistencies on decisions if proofs of debt are being submitted by creditors in multiple jurisdictions. Now, the other big issue in terms of outbound recognition is that there's potentially no protection from creditors. So the moratorium, which prevents new proceedings being commenced against a debtor, will in England will no longer have automatic effect in the EU, and we would need to look to local rules in each country to see whether a moratorium is available. So this could lead to creditors racing to enforce against debtors' assets which are situated in other EU member states, which is clearly not satisfactory. There's also scope for divergence between English courts and EU courts in shared concepts like commie, which has always been derived in English law and construed in accordance with EU law. And that could cause some problems down the line. What all of this means is that we're going to require more and more local advice in cross-border cases, and there's also the potential for delay and cost. Now Alice is going to be speaking in more detail on this, so I don't want to say much more about it. I mentioned outbound, but also on the inbound side. So a judgment in the EU, an EU country, or an office holder in an EU country who's seeking assistance in England and from the English courts. Well, those judgments and those office holders no longer have automatic recognition under the EU insolvency regulation. But there is a reasonable alternative procedure in the form of the cross-border insolvency regulations 2016, which I will be talking about in a moment. Joe, next slide, please. So that was the first significant consequence. The second significant consequence is that both the recast Brussels regulation on jurisdiction, 1215, and the Lugano Convention on jurisdiction and recognition and enforcement of judgments have ceased to apply going forward from the 1st of January 2012. Now, from an insolvency perspective, this obviously affects the general law and commercial matters generally, but from an insolvency perspective, this is particularly relevant to schemes of arrangement. The Brussels regulation was generally relied upon by companies who had agreed a scheme of arrangement under Part 26 of the Companies Act 2006 with their members and creditors, and relied on for recognition in EU member states. Now, there is or an application has been made for the UK to be admitted to the Lugano Convention, which is still pending. It's still in the EU's box. But obviously, well, if that was approved, then that would potentially return us to that position, or very close to it. Next slide, please, Joe. And the third consequence of the end of the transition period is that Brexit has affected the court's procedural rules on service out of the jurisdiction under Part 6. Now, prior to the 31st of December 2020, a claimant could serve a claim form on a defendant outside the jurisdiction under CPR Rule 6.33, where the court's power to hear the case was derived from either the Brussels recast regulation, the Brussels or Lugano conventions, or the Hague Convention 2005 on choice of court. Now, the Hague Convention, it was limited to exclusive jurisdiction agreements made after the Hague Convention came into force. The UK says that the Hague Convention came into force in UK law on the 1st of October 2015. The EU disagrees and says, well, it's not until the UK stands on its own 2 feet, and it's therefore the 1st of January 2021. So there's some disagreement there. But that potentially means mixtures of jurisdiction clauses arguably were not covered under Rule 6.33, which seems unlikely. But now that the Judgments Regulation, Brussels Convention, or the Lugano Convention, and the Hague Convention don't have effect anymore in England and Wales, a claimant can't rely, obviously, on those grounds. So instead, a new CPR Rule 6.33 brackets 2b is going to be added, or the existing one is going to be amended to add, in addition to references to claims which the court has power to determine under the 2005 Hague Convention, also any contract which contains a term to the effect the court shall have jurisdiction to determine that claim. Now that would close the gap going forward, but there is arguably a lacuna which we need to be a bit careful not to fall into. The amendment which is going to be made to Rule 6.33 2b is to be made by the Civil Procedure Amendment Rules 2021. Now that is a statutory instrument which comes into force on the 6th of April 2021. You won't find, as far as I have found anyway, Rule 6.33 2b in its amended form in the White Book or online on the online CPR, which is a rather curious situation. So, and that's obviously because it doesn't have effect. But what it means is that there is a gap of potentially 4 months where, if you're relying upon an exclusive jurisdiction clause, for example, under the Hague Convention, to have served out the jurisdiction without the permission of the court, you may in fact have needed the permission for that period because of this delay in bringing in 6.332b. That doesn't seem to me necessarily irremediable, because one can go back to court and try and seek permission. But of course, it can have other consequences on proceedings, especially if time limits have expired in that 4-month period. So it's just a point to bear in mind if you're in that position. Next slide, please, Joe. Otherwise, if you are serving out, you will need the permission of the court under Rule 6.36, and the usual requirements there apply. So it's a good arguable case. The claim falls within one of the common law gateways for service out, and see paragraph 3.1 of Practice Direction 6b. Secondly, there's a serious issue to be tried on the merits. And thirdly, England is clearly or distinctly the appropriate forum for the trial of the action and the court should exercise its discretion to permit service out. So those are essentially the three main changes that have been brought about by the end of the transition period. So where are we now? Are there, or what are the workarounds that are available to us, and how good are they? Next slide, please, Joe. So first of all, it's worth remembering the certain existing routes that may be helpful. The first is it's possible to wind up a foreign company under English law under Section 221 of the Insolvency Act 1986. Three requirements are: there must be a sufficient connection with England and Wales, a reasonable possibility of benefit to those applying for winding up, and one or more persons interested in the distribution of assets of the company must be persons over whom the court can exercise its jurisdiction. And secondly, the court can appoint an administrator over a foreign company. Paragraph 2 and paragraph 111 of Schedule B1 to the Insolvency Act 86, and that covers companies registered under the Companies Act, companies incorporated in an EEA state, or companies not incorporated in an EEA state, but having their commie in a member state, not Denmark, or having their commie in the UK. So those are, that's the second route that's available to us. And then thirdly, there's also the common law jurisdiction. Well, we know from the Supreme Court's decision in Singularis that this is now really a very limited jurisdiction at the moment. An English court has a common law power to assist a foreign insolvency holder, insolvency office holder, insofar as that is permitted by domestic law, domestic public policy, but that's subject to fairly stringent restrictions, including having to show sufficient connection. Now, I'm not convinced the common law will be the option we're all going to be reaching for in the next few months and years, while some other arrangement is put in place. Next slide, please, Joe. So the more significant workaround is the Untitled model law on cross-border insolvency, which is adopted into UK law by the Cross-Border Insolvency Regulations 2006. Now, the model law was promulgated by the UN Commission on International Trade Law in May 1997. It has been adopted by 49 states around the world, from Australia to Equatorial Guinea, from Israel to Korea, and Singapore to the USA. But it includes, for today's purposes, particularly 4 EU member states, which is Greece, Poland, Romania, and Slovenia. And as I said, it's been adopted into the UK law by the CBIR 2006. Next slide, please, Joe. So there are 4 elements to the model law. First, there's a question of access. So under the model law, or under CBIR, representatives of foreign insolvency proceedings and creditors are given a direct and immediate right of access to the courts of England to seek assistance, and in the form of recognition and relief, and they have the right to commence proceedings under English law. Now, this is tremendously helpful in terms of speed. What it does, it gives the foreign representative standing to participate in a debtor's English insolvency process. But before that's given, the key thing that needs to happen is recognition, and I suppose the touchstone for recognition is whether the foreign court or the foreign proceedings satisfy the test in the regulations for foreign main proceedings, and that is whether the debtor's commie is in that foreign jurisdiction. Alternatively, if the debtor's commie is not in that foreign jurisdiction, but he has an establishment, or it has an establishment there, then we would have foreign non-main proceedings. The third element of the regulations and the model law is the relief. Now, if recognised, the English courts must give relief which is necessary for the orderly conduct of the cross-border insolvency, and this includes interim relief under local law. So it's potentially a very valuable provision to have. And also there are questions of cooperation and coordination between courts and between representatives of creditors and of office holders, which are provided for by the regulations. Now, just 2 points to note here. The model law does not depend upon reciprocity, so it applies to inbound requests from all the remaining 23 EU member states who have not adopted the model law themselves. That's the first part. And then the second point to note is that the model law or the cross-border regulations include no choice of law provisions. So they don't override substantive rights under the proper law governing the parties' debts, which is plenty important. And a point to bear in mind is that although a country may adopt the model law, enacting states are allowed to vary the terms to suit their own domestic law. So this means there are differences, for example, between the CIBR or CBIR and the model law, and the same could be true in every other jurisdiction which has enacted it. So you need to look carefully at the implementing legislation in that jurisdiction for the exact position. Next slide, please, Joe. So several consequences of recognition. As I say, if the foreign proceedings qualify as foreign main proceedings, then the foreign representative, foreign party has automatically the benefit of an English liquidation type injunction, which will give a stay over commencement or continuation of proceedings against the debtor's assets, a stay of execution over the debtor's assets. There'll be a suspension of the debtor's rights to dispose of its assets. Recognition also gives rise to a rebuttable presumption as to the debtor's insolvency. It gives foreign creditors the same rights of access to English courts as local creditors. And the English court has the discretion to grant further relief, which would be available to an English office holder. So that would include the power to examine witnesses before the court, to receive information about the debtor's affairs and assets, and the right to apply to court to challenge fraudulent preferential transactions, for example, and to void, for example, floating charges and extortionate credit bargains. And in terms of practical matters, an application for recognition under CBIR is made to the Chancery Division. And the key question for the court on such an application really is whether or not the foreign proceedings qualify as foreign main proceedings or foreign non-main proceedings. And then once that has been decided and answered, hopefully in the positive, then that unlocks the benefits which the CBIR has to offer. This plainly streamlines the process hugely. It's not quite as good as the EU insolvency regulation, because that had automatic recognition. There is still the step that has to be made and the hurdle that has to be overcome, but it moves a long way towards the old insolvency regulation. Next slide, please, Joe. So proceedings under the CBIR regulations can give rise to a question about whether the Gibbs Principle applies, and this is a principle which comes from the case that's put up there, Anthony Gibbs and Société Industrielle, from the 19th century. And that case is authority, it's taken as authority for the proposition that a debt which is governed by English law cannot be discharged or compromised by a foreign insolvency proceeding. And an exception to that is if the creditor submits to the foreign insolvency proceeding. Now, this ancient rule, relatively ancient rule, has been recently applied in the Bank of Azerbaijan case in 2018. And in that case, the High Court was asked by the debtors' bank's representatives to continue permanently a moratorium on enforcement against the bank to prevent creditors from exercising their rights under an English law contract. And Mr. Justice Hildyard, with whom the Court of Appeal agreed, said no. And he said there's no real doubt that the fact of foreign insolvency, even one recognised formally in this jurisdiction, is not of itself a gateway for the application of foreign insolvency laws or rules, or for giving them overriding effect over ordinary principles of English contract law. So that's the model law and the CBIR. Aside from that, the next helpful workaround is Section 46 of the Insolvency Act 1986, and I'll hand over to Alice, who will take us through that.
Well, thank you very much for that, Raj. My name's Alice Lithgow, and I'm a partner at Fletcher Day in the City of London office. So this is the virtual view from our boardroom window, but I'm of course working from home, same as everyone else at the moment. So Section 426 of the Insolvency Act. Actually, Joe, please can we have the next slide? Section 46 of the Insolvency Act provides for office holders in certain countries to make a request to UK courts for assistance. Now, Section 46(4) states that the courts having jurisdiction in relation to insolvency law in any part of the United Kingdom shall assist the courts having the corresponding jurisdiction in any other part of the United Kingdom or any relevant country or territory. So this includes the Channel Islands and the Isle of Man, and I know that Adam's going to be speaking about Guernsey and the position there in due course. So most of the designated countries comprise of Commonwealth countries, and I can read you a list and it will be quite marked as to how few countries there are in the EU. So the complete list is Anguilla, Australia, the Bahamas, Bermuda, Botswana, Canada, Cayman Islands, Falkland Islands, Gibraltar, Hong Kong, Republic of Ireland, that's the European one, Montserrat, New Zealand, St Helena, Turks and Caicos Islands, Tuvalu, Virgin Islands, Malaysia, South Africa and Brunei. So actually the Republic of Ireland is the only European designated country. We also have Gibraltar, which is no longer part of the EU after Brexit and is now British overseas territory, but it's open to their office holders as well. So can I have the next slide, please, Joe? So this isn't a comprehensive list of what remedies are available. It's quite a wide-ranging process, but overseas office holders can apply for assistance in obtaining an order for an injunction, a declaration recognising the rights of a foreign insolvency representative, or even the making of an administration order. Now, it can't be used to enforce foreign judgments, but that's something I'm going to be looking at later on in my section of the seminar. Thank you. Thanks, Joe. So interestingly, Section 46(5) of the Insolvency Act allows the English court to apply English law, but also the law of the requesting court. So this can be quite useful to foreign office holders. So someone in Ireland could, for example, apply to the English court for assistance applying Irish law or English law, and this will widen the powers that they may be able to use. So this will be quite a large factor in considering whether to go down this route or whether to go down the model law route, which Raj has already explained. Next slide, please, Joe. So the potential downside of the process is it does take longer because it's a two-stage process. So the local lawyers in Ireland or Gibraltar or somewhere else overseas will need to make an application to their own local courts to request a letter of assistance from the English court and for an order giving an effect to the letter of request. At this point, we would be instructed and then we would go to the English court requesting assistance and making an application here. Now, in practice, English courts will normally rubber stamp the request for assistance, and that's expected of them. There would have to be a very powerful reason for them to say no to what's being asked. So we're very generous with overseas. We give lots of assistance, but there isn't really a lot of reciprocal assistance. Obviously, it depends on individual countries. In Ireland at the moment, there isn't an active provision. So this may, of course, change as the months develop. Guernsey has a similar incoming provision, I understand. And again, I think Adam's going to be dealing with this. So it remains to be seen really whether Section 426 is going to be expanded to other designated countries. I mean, maybe it will be expanded to all other EU member states, and also whether EU countries will introduce reciprocal measures in due course. But of course, we just don't know about that at the moment. So moving on to the next section, Raj has looked at how we've looked at how we enforce English insolvency orders overseas. So we're now looking at how to recognise EU states, orders from EU states. Now, the magic cut-off time, which Raj has already mentioned, was 11 p.m. on the 31st of December. So we no longer have automatic recognition unless proceedings were issued before this cut-off time. So really now, the question of recognition is going to depend on the private law of the country where recognition is sought. And we're going to be pulling out our address books and building up contacts with local lawyers in Europe going forwards. If we get stuck, the Foreign Commonwealth and Development Office provides a list of English-speaking lawyers in various countries, which may be useful. Another useful resource is that the Insolvency Service has produced a booklet which is online and entitled Cross-Border Insolvencies, Recognition and Enforcement in EU Member States from the 1st of January 2021. This booklet contains a very useful summary of the legal position in each of the countries within member states, which is a very good starting point when you're trying to investigate what to do. So as Raj has already mentioned, 4 countries in the EU have implemented the Untitled model law, and it's possible to apply for recognition order in the following countries. So we have Greece, Poland, Romania and Slovenia. And as when countries are making incoming applications here, the relevant court will assess the insolvent centre of main interest and establishment to assess whether an order can be granted. Now, I thought it might be useful to have 3 examples of how the local laws operate. Broadly speaking, other countries fall into 4 categories. So some countries in the EU will automatically recognise our insolvency orders, and office holders can simply proceed without making further applications to court. Other jurisdictions, it will be necessary to make a similar application to the court as that for a recognition order, but it won't be under UNCATRAL, it will be using the relevant local law. In some jurisdictions, there's a hybrid of automatic recognition. You may be able to automatically take some action and then need to apply to the court for other actions. And the final category of countries is where foreign insolvency proceedings are not recognised, and it may be necessary to commence fresh local proceedings, which is obviously going to be expensive and long-winded. So I've just picked 3 countries just to look at in a bit more detail. I'm not a local lawyer, so I've taken this information mainly from the government booklets. In France, UK office holders have some degree of recognition in France automatically. So an office holder can represent a debtor in court or realise funds from a bank account without obtaining a court order. More crucially in France, office holders need to obtain an order called, I believe this is pronounced exequatur, which is a formal order recognising their appointment. Now, this is very important because until this is obtained in France, the debtor retains all its powers to deal with the company's assets. And so it's not the case that the assets automatically vest in the office holders like they would in this country. So the application for an exequatur can take about 6 weeks, so it's worth planning this in advance. And the office holder has to file a writ of summons against the French public prosecutor, and this is filed with an official translation. Once it's obtained, it needs to be published in a French official legal announcement. And interestingly, French courts will normally apply foreign law, so they will apply our English law in administering the insolvency rather than opening their own local insolvency proceedings. So the position in Germany, on the face of it, seems far more straightforward than that in France, because UK insolvency proceedings are automatically recognised in Germany under the German Insolvency Code. And it's spelt out quite clearly in section 343 of the German Code, which provides for the automatic recognition of foreign insolvency proceedings, as long as the court of the originating country has jurisdiction in accordance with German law and recognition doesn't violate German policy. So it will still be necessary to have German legal input. In practical terms, it's normal for a UK office holder, I understand, to apply for official recognition because it avoids any arguments over it. And it also gives better access to obtain access to assets via third parties. So although there is automatic recognition, there's a convention that you would apply to the court in any event. So Hungary, I have included, it's not one of the more mainstream countries, but it is one of the ones where there is no reciprocity of recognition. So it's really untested at the moment what would happen, but it's thought that UK proceedings wouldn't be recognised and it'd be necessary to start fresh proceedings within the jurisdiction. So that's the position with enforcing English orders overseas. But we're now, next slide please, Joe, enforcement of UK judgments in EU member states. So office holders may find that they have a judgment over here and they're wondering how they would go about dealing with this overseas. So again, at the magic cut-off time, 11 PM on the 31st of December 2020, the recast Brussels regulation, the 2001 Brussels regulation and the 2007 Lugano Convention have ceased to apply. There are two exceptions to this. Again, if the proceedings were actually commenced before 11 PM on the 31st of December 2020, the old rules will still apply. And also, as Raj has touched upon, we're now contracting to the Hague Convention on Choice of Court Agreement. So if there's an agreement designating a particular court, then the old rules will still apply in those instances. So otherwise, the position is going to be far more piecemeal and relying on local law, and we're going to be getting back in touch with our local contacts in Europe. The one exception to this is Norway. We have a treaty with Norway, and that was signed by the two countries on the 13th of October 2020. So we have a fairly concrete idea of how we're going to be able to enforce a judgment in that jurisdiction. There are also some historical bilateral treaties between the UK and various countries in the EU, which I've listed. They're Austria, Belgium, France, Germany, Italy, the Netherlands, Cyprus and Malta. But these were superseded by the European regime. So really at the moment, it's early days and we don't know whether these are going to be revived. Even if they are, they're quite limited in scope because they only apply to money judgments. They only apply where the court has jurisdiction on a limited basis. And there's also a necessity to obtain a declaration of enforceability, which makes the whole process long-winded and adds to the expense. So really we're looking at the position under local law. And in France, for example, it would be necessary to file a claim for an exequatur and then to use local laws in order to work out how to enforce the judgment. So there is one caveat on this, the position's piecemeal at the moment, but the UK has applied to accede to the Lugano Convention. If this is agreed, the EU need to agree to it, then it may be that everything becomes uniform and unified again, but we're just not in that position at the moment.
Thanks, Alice, and thanks, Raj. Good afternoon, everyone. As you'll see from the slide there, I've rather grandly titled this section by reference to a Channel Islands perspective, but it is worth noting at the outset that Guernsey and Jersey each have their own laws, their own courts, and that there are some fundamental differences between the islands' insolvency regimes. So Jersey, by way of a quick example, doesn't have administrations, Guernsey does, and even the tests of solvency across the two islands are different. So in reality, as soon as I'm faced with a case that touches on any Jersey law element, then I'm quickly on the phone to my colleagues in our sister island. But I hope that for the purposes of this talk, a number of parallels can be drawn between the islands. And whilst I'm only qualified to speak about Guernsey law, I hope that by doing so, I can also help to highlight the sorts of issues that you may encounter in a broader and wider Channel Islands context. So with that said, the simple point from a Channel Islands perspective is that Brexit hasn't caused any real changes to our approach to assisting foreign office holders. The reasons for that are, despite the close and historical ties to the UK, neither Guernsey nor Jersey have ever been part of the EU, and as such, the EU insolvency regs haven't been a particularly relevant factor in questions of recognition or mutual assistance for us. Incidentally, the islands also aren't signatories to the Untitled model law, nor any other recognised insolvency regime, and so we are therefore very much focused on domestic positions in relation to these issues of recognition and assistance. All of that means that Guernsey has a twin track regime for recognition of UK and non-UK office holders. For UK office holders coming to Guernsey, as Alice touched upon, we're looking at section 426 of the 1986 Insolvency Act, which has been extended to Guernsey since 1989. That means that the Royal Court of Guernsey is mandated to assist the courts of England and Wales, plus Scotland, Northern Ireland, Jersey, and also the Isle of Man, in relation to insolvency proceedings. And the process for recognition is obviously a familiar one to many of those listening in. But by way of a quick recap on what Alice said, it involves a letter of request from the relevant UK or Crown Dependency Court into Guernsey's Royal Court, and thereafter that secondary element of the application to give effect to that request. Requests are routinely granted. They're at the court's discretion, but they will invariably be granted unless they're considered to offend the island's public policy, or if the outcome is deemed to be an oppressive one. For completeness, and also because it ties into something that I want to touch on later in relation to the Corporate Insolvency and Governance Act, office holders appointed in jurisdictions that are outside the reciprocity scope of Section 426 would need to rely on the common law principles for recognition. And that means satisfying the pretty well established sufficient connection test, which over here would typically be done by showing that the office holder was firstly appointed in the relevant appointed in the jurisdiction where the relevant company is incorporated, or in the case of an individual, where that individual is domiciled. And secondly, that the relevant party submitted to the jurisdiction of the court that made the appointment. So if we can flip on the slide. Turning to the sort of assistance that UK office holders will get from the Guernsey Court, where a request is granted under Section 426, then our court has the flexibility to decide whether or not it should apply English law or whether it should apply Guernsey insolvency law. The powers afforded to office holders under Guernsey law are not as explicit or potentially as robust as those set out within the Insolvency Act, and key practical differences between our regime and the UK's include Guernsey not presently having a statutory provision for setting aside transaction at an undervalue, and also our IPs having more limited investigative powers than those that are available to UK liquidators and administrators under the Act. But the effect of 426 is that the Royal Court does have the ability, even if not the requirement, to grant UK office holders the sorts of powers that they're entitled to call upon at home, and with which many of you will no doubt be very familiar. Given this discretion to apply either law, there is the potential for uncertainty over the ability of UK liquidators to utilise the full range of tools that are available to them in their own jurisdiction. But in practice, we haven't seen this as a particular problem. And I think provided the use of UK founded powers can be justified to the court, then there's little scope to expect that the discrepancies between the two regimes will cause any significant issues. In this regard, I think we can also draw some comfort from the fact that Guernsey's insolvency law changes to that law have been approved and will shortly come into force, and that those amendments will put the powers afforded to Guernsey IPs on a very similar footing to those of UK practitioners, which should effectively remove the concerns around whether the relief available to a UK office holder can also be achieved here in Guernsey. That either or approach to the law to be applied under Section 426 is different from the approach in relation to common law recognition. This means that non-UK or Crown dependency office holders could find themselves being denied assistance to bring a claim unless the specified type of intended action actually exists under Guernsey law. But again, hopefully that sort of issue should be largely resolved by the impending changes to Guernsey's insolvency law and the broad equivalence that this will bring with the standard powers and reliefs that we typically see in countries that take their insolvency cues from the UK or that have comparable regimes. If we could move the slide on again, please, Joe. So in order to round out the story, we can deal very quickly with the current position for Guernsey office holders seeking assistance from the UK courts. Again, there's no real impact as a result of Brexit, and the process that Alice touched upon operates from a Channel Islands perspective as a mirror image of what it is I've just outlined for our incoming requests under 426. For the reasons I've spoken about in relation to office holders' statutory powers under Guernsey law, recognition into the UK has been an effective tool for access to the more expansive powers afforded to liquidators and administrators. And it's one that's been pretty commonly explored where you've got that international aspect. If you could move the slide again, please, Joe. So it's almost unthinkable at the minute not to try and weave the pandemic into any conversation. And whilst I don't really want to do that, I thought it was perhaps helpful to try and look beyond Brexit and to consider whether anything had changed as a result of last year's Corporate Insolvency and Governance Act. Now, SIGA obviously doesn't apply in the Channel Islands, but we have been paying pretty close attention to its effect. One of the most interesting cross-border aspects seems to be the impact of the new Part 26A restructuring plans. And if those RPs continue to gain popularity in the way that many of us expect they will, particularly given the option for things like the cross-class cram downs, then we should expect to see queries about the ability to use restructuring plans in relation to Channel Islands companies. So it would obviously be a matter of English law whether a foreign company can benefit from a restructuring plan. But my assumption is that for a Guernsey company, that would involve little more than surmounting the sufficient connection test in the sorts of ways that we might expect the court to apply for the winding up of a foreign company. In terms then of Guernsey recognition of an RP in order for the English court's order to be given effect on the island, the position does seem to be a little bit more nuanced. And the key here is that RPs have been incorporated into the UK Companies Act rather than the Insolvency Act. And as such, the Section 426 route wouldn't apply. So that brings us back into the common law route for recognition that we've touched upon. And actually in this instance, probably the standard requirements for enforcement of a final and conclusive judgment. So for restructuring plans that relate strictly to the compromise of English law debts, and where all parties have submitted to the jurisdiction of the English courts, Guernsey recognition may well prove to be pretty straightforward. Where, however, the restructuring plan has dealt with creditors' rights arising under the law of foreign jurisdictions, or where it's been ordered in circumstances where some of the creditors didn't participate in the compromise arrangements, then the scope for recognition might not be quite so clear. At that point, we might need to carefully consider other workarounds, whether something can be achieved through maybe a parallel Guernsey scheme of arrangement. But as I say, we're all watching this pretty rapidly developing area and continue to look with interest to see where the limits of RPs ultimately come to lie, albeit with that probably natural degree of expectation that these sorts of issues will increasingly come to touch on the Channel Islands. So Raj, I know from conversations we've had that restructuring options have certainly been on your radar. So hopefully that affords me a decent point to hand the floor back over to you.
Well, Adam, thank you very much. And it's really great to have that perspective here and to have the chance to hear a perspective from another jurisdiction, albeit one that's very, very close to England. So thank you. And thanks, Alice, as well for your section. So yes, just on restructurings that I mentioned in passing a bit earlier, and I just wanted to touch upon briefly the position for formal restructurings post the 1st of January 2021. And I want to speak about schemes of arrangement under Part 26 of the Companies Act 2006 and the new restructuring plan under Part 26A of the Companies Act 2006. You'll be familiar, I'm sure, with the differences between plans and schemes, but just to highlight three of them. For the scheme, you need a sanction of a majority in number of the creditors and 75% by value of the creditors or members, whereas in contrast, a plan under 26A just needs a sanction of 75% in value of creditors or members. And secondly, Part 26 schemes apply irrespective of the financial condition of the company, whereas a Part 26A plan applies only if the company has encountered or is likely to encounter financial difficulties that have affected, will affect, or may affect the company's ability to carry on business. And then, as Adam touched upon, the Part 26 plan introduces the concept of the cross-class cram down, which is a bit of a mouthful, and essentially you don't necessarily need the sanction of each of the classes of creditors or members involved. And I just wanted to briefly, as my sort of final point, just mention this case. Oh, sorry, Joe, could you slip on to the next slide? That's it, thank you very much. So it was this case, Gate Group Guarantee, a decision of Mr. Justice Zaccaroli on the 17th of February 2021. I should say, Mr. Justice Zaccaroli has an ability to write very clear judgments. So if you ever have an opportunity to read one of his judgments, I'd recommend it. I appeared against him when I was a solicitor yonks ago, and he was junior counsel, and his pleadings were read like books, and he seems to have carried that skill through to his judgments. So this judgment actually makes what is potentially a very complicated area seem very simple. I say relatively simple, but I would commend the judgment if you have a chance. That particular case concerned an English company which had applied for approval of a plan under Part 26A. The court had jurisdiction to wind the company up under the Insolvency Act because it was an English company, and so it was a company to which Part 26A applied. However, the court had to consider whether the Lugano Convention applied in that case, and that was because the bonds, which were effectively the object of the plan, contained an exclusive jurisdiction clause in favour of the Zurich courts. Now, the Lugano Convention was in play because the plan was launched on the 30th of December 2020, so just in time before Lugano ceased to have effect in England. The Lugano Convention provides at Article 23 that if the parties have agreed to an exclusive jurisdiction clause in favour of a particular court, then that court has exclusive jurisdiction to deal with any disputes in relation to that matter. So if Lugano applied, then the Zurich courts had jurisdiction. The English courts could not determine the question of the plan under English law. But the Lugano Convention also includes a provision saying it doesn't apply to bankruptcy proceedings relating to the winding up of insolvent companies, judicial arrangements, compositions, and analogous proceedings. And Mr. Justice Zaccaroli called this the Bankruptcy Exclusion. Now, it's settled practice, even if it's not clear in the case law, that schemes under Part 26 are not insolvency proceedings. So therefore, the recast Brussels regulation or Lugano Convention applies to schemes under Part 26. It's also well established that there is dovetailing, as it's called, between the Brussels regulation and the insolvency regulation. So a case should fall into one or the other regulations. It's either an insolvency proceeding or it's not. And there should be no overlap between cases and no vacuum, no space between the two of them. The judge in the Gate Group case concluded that a plan under Part 26A was an insolvency proceeding for the purpose of the Lugano Convention. And because Lugano therefore did not apply, the court did not have to give effect to the exclusive jurisdiction clause in favour of Zurich, and the English courts had jurisdiction to determine the matter. Now, so we have the different characterizations of Part 26 and Part 26A, even though they're next to each other in the Companies Act. Going forward, for schemes, now that we don't have the Brussels regulation, Lugano, we may need to rely on the Hague Convention or Rome regulations, or possibly the model law for recognition in the EU of schemes. If we accede to the Lugano Convention, which may happen later this year or next year, then schemes under Part 26 will be dealt with differently, which is under that Lugano Treaty, which takes account of exclusive jurisdiction clauses. But plans, if this judgment is followed, under Part 26A will not be treated in the same way. Now, it seems to me this is surely not intended, but what it does show, it adds layers of uncertainty and complexity in this area. So in conclusion, I would just say watch this space. Final or next slide, please, Joe. So what next? I think for now, in the immediate term, it's going to be the model law dealing with inbound insolvency requests and local jurisdictions for outbound. That is, we're going to have to go and find out what the French lawyers have to say, the German lawyers have to say, etc. And that's the workaround that there is at the moment. In the medium term, it's possible that more EU states will adopt the model law, but that could take a long time. As we've seen, the EU doesn't always move very quickly. Also in the medium term, the EU may agree overall to allowing the UK to join the Lugano Convention. But what we have is we do have some uncertainty at the moment, which ultimately is going to lead to more work for lawyers and probably doesn't help creditors necessarily. But that is the situation that we have at the moment. So just on to the final slide, please, Joe. I've just had a quick look at the questions. We've got a clear list on the questions, so we've obviously answered everything in advance, and I'm mindful of the time. So it just really remains for me to say, well, thank you first of all for listening and for joining us today, and enormous thanks to both Alice and to Adam for contributing and for helping out with this talk. We hope you found it useful. If you have any questions at all on any aspects of what we've discussed, please don't hesitate to drop us a line, an email. We'll be very happy to have a chat about any of these points. Otherwise, I hope you have a really good rest of Friday and a good weekend. And we look forward to seeing you at the next one of these webinars.
Thanks, Raj.
Bye-bye.
Thanks, Raj.